Sure, go ahead.
Number one, Peterson and Peterson was on for review 2 weeks ago. Leave your honor the procedural history. Miss Peterson is present and appearing pro se. Ms. Height is the GAL. She's present. Ms. Peterson filed a motion back on January 4th to modify the visitation. Responses were filed. It was heard by your honor on February 7th. At that time, Ms. Peterson was requesting an increase to a 50-50 plan, and the court, based on the order that had been entered by Judge Hahn, seeing that some evaluations had not occurred and treatment had not occurred, set it over for review March 21st. I was in trial March 21st. Ms. Baldwin appeared on my behalf, argued for a continuance, and in light of the fact that it appeared from what had been filed with the court that Ms. Peterson had made the evaluation that was ordered, the court followed the parenting plan that had been on temporary basis by Judge Hahn and moved her to unsupervised visitation every other weekend. It was set over a week to review in the event that I had anything to add. Notes from Ms. Baldwin were basically that your honor had indicated that because she had met at least substantially the requirements of the parenting plan on a temporary basis that was ordered by Judge Hahn, the visits would increase, but put it over in the event I had anything to add. I appeared and asked to have the matter struck on that date. Ms. Peterson wanted to continue arguing for the 50-50 plan that she had initially filed in her motion that was heard back on February 7th. Commissioner Nelson was on the docket. It was set over to today to review. My position is the motion was filed. It was heard on February 7th. Your honor reviewed it on the 21st. Increased visits based on Judge Hahn's prior order. There isn't any motion in front of the court. There isn't anything more to argue. That's my read of the situation, which your honor had ruled back on the 7th and on the review on the 21st. So my position is it should be struck today.
Hey, give me just 1 second. I'm looking at the so the parenting plan, and I'll give you a chance, Ms. Peterson, to be heard. Just gonna talk out loud here for a moment. So the parenting plan that I was referring to and kind of reinstituted the I don't want stage 2 or step 2 or whatever we were on is the one from June 7th, 2022. We all agree on that. And that it goes from visits to longer visits to alternating weekends from Friday at 7 p.m. to Sunday at 7 p.m. with a midweek 3-hour visit. And then allows for, if Ms. Peterson is at the level 3, it allows for a longer vacation time in the summer. So, and then the motion for, when did you say, Mr. Baldwin, the 50-50?
It was filed on, sorry, Judge, it was filed on January 4th in a motion for temporary orders. Response on the 18th. It was heard by your honor on February 7th in argument. At that point, there had not been the input psych evaluation done that was required by Judge Hahn. So that was set over to March 21st to review. On the 21st, Ms. Peterson had filed that she had completed the evaluation. It recommended 1 hour a week of psychotherapy. At that point, your honor ruled that she had met that condition functionally. She'd been engaged in counseling for the entirety of the year prior. The only issue, and at least what's been filed, is the recommendation is for 1 hour of counseling a week. What was filed on the 23rd of March shows a 1 hour appointment with a therapist and then 2 half-hour appointments. So not meeting the full requirement, but enough, at least at this point, the court had determined she had met that precondition to move to the unsupervised alternating weekends. We aren't arguing that at this point, only that it seems like Ms. Peterson's of the opinion that the court is intending to review this further than my impression from the court's ruling and the prior hearings. And that's why I thought it should be stricken in court 2 weeks ago. I made that motion to strike, but because Commissioner Nelson hadn't heard it the week prior from your honor, it got put over to today to review. And despite all the words, I still think it should be relatively straightforward from the procedural history. So I thought this could be one that the court could resolve quickly.
All right. Thank you, Mr. Baldwin. All right, Ms. Peterson.
I disagree. One of the motions that was filed was to review the temporary parenting plan that was already set in place. The guardian ad litem has then submitted her report back in August. Dates were filled at the original hearing to be set for review of that report. During that, because they wanted to do a set over because I hadn't completed the court's required mental health evaluation with the petitioner's input, it was set over until I got that input. That evaluation was done, which allowed me to move to the next step, but that is not to do with the petition of moving back to the 50-50, not this temporary parenting plan is currently in place.
Okay, so this is how I see it. And obviously there's, some room for interpretation here. There's already a temporary parenting plan in place. You are maxed out on that parenting plan at this point. So you're back to, I think, first, third and fifth weekends, Friday to Sunday. There is no provision for 50-50 in the temporary parenting plan that's entered at this point in time. If you are wanting to revamp the entire parenting plan, then we have to go through an adequate cause process. And I don't think that we're there yet. So I unfortunately agree with Mr. Baldwin. I don't have the information in front of me to completely reconsider the plan. You're back to visitations and regular weekends with the kids. That's only been a couple weeks that's been happening. Is that correct? Or maybe up to a month?
No, that is correct, Your Honor. But at the same time, this took place a year ago, and I've been trying to get this back in court since then by myself.
I understand that, but we just now got to phase 3 in the parenting plan that was entered in June of last year. So I can't give you legal advice, but to change a parenting plan that drastically, there needs to be a finding of adequate cause, and there's a different process. There's a process that needs to be followed for that. So at this point, I'm not going to set another review. You're free to file whatever you want to file and set it before the court. And I'm happy to review everything and hear it. But at this point, I'm not inclined to immediately jump beyond the parenting plan that's in place right now back to a 50-50 when we have a temporary in place. 08 on for temporary orders.
Thank you, Judge.
Napoleon Thompson.
Thank you.
And Irina Thompson. And I have
This looks like
just for the record, Acacia Dawson and a Sarah Davis in the waiting room that don't match up with anything I have. So sorry to interrupt you. Go ahead.
No, that's fine, Judge. This is the second or third time this case has been before the court. There's kind of a history of Ms. Thompson showing.
Go ahead. Sorry.
Ms. Thompson showing up and asking for continuances. The court has granted those in the past. There was kind of a drop dead date as of, I believe, a week or two ago, in which the court said she was to retain counsel or file a response to the motion. Ms. Bliss informs as of April 7th, she has not received any kind of a response to that. Well, we're just simply asking that you sign off and enter the proposed temporary orders as drafted and submitted back in middle of February in anticipation of this motion.
I did review the minutes in the record. It does appear to me that Ms. Thompson was pretty explicitly given until the 31st to file a response. And nothing's been filed. There's been no notice of appearance by any parties in this case. I have reviewed the temporary orders, the parenting plan, the child support orders. I have those in front of me and I am signing them.
Thank you.
Thank you.
Let's take motion based on kind of where we were with the GAL orders that were entered within probably a year or two ago, in which some of the language was modified. In any event, I do represent the moving party, Natalie St. Peter, here on Natalie's motion to reappoint Ms. Height as the GAL, and basically just to give us an update. And my client has detailed for you, Mr. Brooks has responded with some of his answers to that. But after review of the file and the motion before you, it's clear to see that there has been some bubbling and developing issues between the parties in regards to these two young boys over the past 9 months or so since Ms. Height issued her report. Paragraph 11 of that GAL order is pretty clear. That was kind of the language again during that time we were drafting and including. But it basically leaves the door open for either party or the GAL to come back and essentially ask for kind of an update of what's happened since the issuance of that order, or excuse me, of that recommendation. And that's what we're asking for today. That language specifically states the GAL appointment ends when the GAL files the final GAL report, unless otherwise ordered by the court, or any party, including the GAL, may motion for reappointment as needed. Again, that gets into kind of the crux of my client's concerns, which have been kind of detailed at length related to the bruising on one of the children's arms. It's a case in which domestic violence was alleged at the onset of this case. It went quiet, thankfully, for a period of time. We're now in a position where we're starting to see some issues with the boys coming back from dad's house with bruising. We got the issue with the tongue, with bruising under the chin on separate instances. And ultimately, this CPS referral that was made by who we believe was the doctor. Again, that's information that's right for the GAL. Ms. Height is, in my experience, extremely thorough and timely in getting stuff out and investigating new matters. Given the language of that order, coupled with some of the things that have occurred over the last month, that seems like an appropriate request. I also have this issue of the kids getting violently ill a month and a half ago. Now, there's some competing allegations and some competing details about how that happened and what the context of that were. Again, we're not suggesting that anybody intentionally got their kids sick, but what we do fear is that there was some exposure that was kind of minimized. You look at the communications between the parties, again, that shows two sets of parents who are having communication issues. My client's contacted after a visit, almost immediately after a visit by the father, who says, "How are the kids feeling?" She thought that was odd, given the timing of that, because that's not something Mr. Brooks has traditionally done. Come to find out, both kids the next day become violently ill with strep throat, significant ear infections, which led to stomach issues. And after repeat visits to the doctor in the ER, my client details me that's as sick as they've ever been. It's not until we get Mr. Brooks's response that we find out that he was kind of reaching out because he had been violently sick himself. My client in that weekend prior, or excuse me, during the visit, asked him how the kids were doing, was essentially told we're having the time of their life. Don't worry about it. Don't contact me unless it's an emergency. We provided you with that correspondence. And again, she left to kind of pick up the pieces. Mr. has alleged in his response these matters about, well, she's essentially making things up and embellishing on this. It's not the way it was. And again, we've given you communications which directly refute what he said. This is a case that has not yet been set for trial. Now, this is one where I would imagine the court is going to want the most recent and updated information from a GAL. And as the language is concerned in that order, we would just simply ask that that be also amended, that Ms. Height can kind of stay involved up through the time of trial, as we now routinely see in those updated GAL orders. That's the request. I think it's a logical one and a reasonable one given where we're at. We were somewhat surprised to see that Mr. Brooks was contesting that. Saying he didn't want that, that was appropriate. And again, it just seems kind of par for the course and kind of how this case has evolved over time, that something as reasonable as just asking for a second look and an updated look from the GAL is being met with this much resistance.
Great. Thank you,
Oh,
Mr.
and before I end my session, I would like to just kind of suggest that we just keep the percentages for the GAL based on the existing order from last year.
All right, thank you. Good afternoon. Any response?
Good afternoon, Your Honor. Thank you. I would just say, Mother's motion and her reply just reek of hostility and resentment toward father. This has been an ongoing theme throughout this case. She didn't raise any concerns until Dad wanted a set parenting schedule, and then she had all these allegations. We had Ms. Height do a report, and that was issued. There were no concerns with father. In fact, it was acknowledged in the report that Mom had actually acted inappropriately by doing things like apologizing to the kids when they had to go to parenting time with Dad instead of fostering that relationship with Dad. And now, Mom's making these new allegations. It's like trying to hit a moving target with her. First, she makes these allegations about the DCYF case, and then now it's about the kids being sick. And Mother doesn't deny in her reply that this report was a family assessment. It wasn't an actual investigation. But that doesn't fit with her narrative. So now in her reply, she just sort of skirts around that and makes it about the kids being sick, because that doesn't fit her narrative. But the reality is that both these parents cooperated. The caseworker had no concerns, and she can't deny that. So she, again, pivots to now it's about the health of the kids, whereas these kids go to daycare. They're sick all the time. This is not something that's new. And when Dad asks how the kids are doing, how they're feeling, she just goes off on him and berates them. And she's basically just throwing things at the wall to see what sticks. And DCYF had no concerns. This wasn't presented as just taking a second look. This was directly accusing Dad of doing something wrong. Of course, he was going to take issue with the fact that was the way that it was presented. It directly accused him of something that DCYF just didn't see. And so we are asking that a GAL not be reappointed, and if one is reappointed, that mother pay for the GAL in full. Thank you.
So I see this kind of a twofold. It clearly mom has maybe a specific concern, maybe it's a broader concern. But in my reading of the declarations, dad seemed to share some of the frustrations and some of the kind of ongoing issues that I think that Ms. Height tried to address in her initial report, which I will note is almost a year old at this point. We do have two young, I think they're both boys in this case. And I do have some concerns given that the behavior back and forth. My hope is that I'm going to appoint Ms. Height to kind of just readdress and refresh the report, look at interactions between the parties and the well-being of the boys. I'm going to keep the same percentages at this time, but I'm going to allow argument for a potential fees if we see absolutely no issues and everything is status quo. Then I think the respondent would have an opportunity to request for some of that money to be paid back. So I'll make note of that. But I will reappoint Ms. Height and at this point keep the same percentages that were previously ordered.
And I'm sure when the attorney's meeting is probably agree to an order. Ms. Belli, do you think there's a need for presentation, or can we just get this signed off on in the next couple of days?
Yeah, I think that would be fine.
And
Can I change?
Sorry, go ahead.
Are you agreeable if I modify that language to what the more current orders reflect, which is GALs appointed up until the time of trial or dismissed by the court? Or do you want it to remain?
That's fine.
Go to that. All right.
Yeah.
That's fine.
Thank you.
And then I guess, are you going to ask for an interim report or just a final report in that order?
No, just a final report.
Okay.
I think that would probably be sufficient for now. And if anything comes up or anything's uncovered by either party, we can note it back up as necessary.
Okay. So if you could shoot a copy of that to Ms. Height so she knows the dates that she's working with and can start as soon as she has the ability to.
Thank you.
All
Thank
right.
you.
Good luck. Thank you. Okay. And I just wanted to, so I've reviewed everything here. Well, you say that, and then you want me to look at something, 3 months earlier than I did, but I reviewed everything recently in this file. It does appear though that and I just want to confirm this, the initial GAL that filed the report is not a GAL anymore. Is that correct?
I believe that's correct.
Okay.
She's long since been removed. I think she's up north in Whatcom County or someplace. So that's part of the issue and kind of where we're at.
Okay. I just wanted to, I thought so, but I just wanted to confirm that. All right.
And I think that's been that way for several years now.
Okay. All right. Thank you for answering that. And then I will defer.
Thank you, Your Honor. As the court's aware, I do represent the moving party to the motion before you today, namely Joel Stone. And this is a case I think that's pretty specific kind of as to how we got to this point. My client has always been extremely involved with his child. He's always had a very good relationship with Ava. He's always gotten along very well with Ava. Things have always been good, provided they are on Ms. Riverio's terms. And unfortunately, that's where we've been for the better part of a year and a half with this case. And we're now before the court seeking some kind of relief so that my client can get back to that relationship with his child. From a procedural standpoint, this is unusual. This is a case where the parties were before Judge Cruiser for trial back on September 18th, 2018. There was findings made. There was a final a final parenting plan was rendered at that time by Judge Cruiser. Under paragraph 4, it has some unusual findings and provisions in that. What no one contemplated at that time was the fact that these parties, within a very short period of being in court, were going to reconcile. My client continues his relationship. The parties live together. They are going about their business. They plan to be married throughout 2019, 2020, 2021. They made plans for that. And we've given you the text communications that confirm that. They're talking about beach weddings. They're talking about going to Hawaii. My client has provided you with pictures. Again, we're not talking isolated where you go and get 10 pictures for one visit. We're talking about over an extended period of years in which the child is maturing and growing and aging. And you can see that from the evidence that's been provided. And my client, again, is right there, every part of the parent that Ms. Ribeiro is during this period of time. We then filed, in 2021 of October, Ms. Ribeiro finds out that my client, the relationship is over, that my client is dating a new individual. And then conveniently, over 3 years after that parenting plan was instituted and implemented and signed off by Judge Cruiser, mother says, well, too darn bad, you're going to have to comply with what the judge said 3.5 years ago that nobody followed then or since that period of time. That leaves my client completely on the outside. That leaves the child completely on the outside, missing her father. And now we're in this position where my client, on a pro se basis, representing himself, attempts to come back involved, files a modification, not knowing what to do, brings his actions before the court, again, because of the procedural issues that we have contained in the parenting plan, which are directly caused by the fact that nobody anticipated the parties would get back together and contemplate marriage and act as essentially a quasi-community during that period of time and co-parent this child who at the time was fairly young. We were somewhat surprised when we got the responsive pleadings from Ms. Ribeiro denying all of that, saying that my client hasn't been around since 2018, that there was no marriage talk, that none of these issues, that he's been causing problems, showing up uninvited and causing a scene at Christmas recitals and birthday parties and the like. And literally within a brief period of time, my client responds to you and we file for you not only the pictures and evidence completely contradicting everything she said, but text messages directly from her, which state that not only was he welcome at these events, but was an asset at these events. She talks about the dress for the Christmas party. She talks about, I believe it was the Sky Zone event planned for the child. She talks about all these different things and tells my client how great it was that he was there, how the child enjoyed it, and the like. So if we're looking at this from the perspective of who's telling the truth, I know that a lot of times there's black and white statements and the truth is somewhere a shade of gray. But this is one in which the evidence completely contradicts everything that mom has stated. Effective and jumping forward again to October 2021. Now, my client is unilaterally just cut off. He decides and is told, well, you got to comply with the court order. Sorry, that's just the way it is. So what does he do? He bites the bullet. He goes in and he does the 52-hour high conflict parenting class. He provides you with a copy of that. He goes and gets the domestic violence evaluations, one from Miss Lovely. I'll get to that in a moment. Another one from the same outfit that gave the parenting class certification. We've filed that for you. He's attempted to make contact with his daughter, again, who he misses tremendously and who misses him, and is rebuked at every step of the way. We thought we were making some kind of progress and headway in the fall, trying to set up and commence these visitations. And again, Ms. Ribeiro decided, nope, not going to let you do it. I'm going to continue to withhold the child, despite the 3.5 years of history since the time we were at trial, and nobody regarded those orders whatsoever. We lived together and planned our future together. So if we look at it from that context again, and we look at it from just a simple, what's the best interest of this child? Well, the best interest of this child is to have a relationship with mom and dad. And that's what this comes down to. To both of their credit, they both acknowledged that and realized that after the trial in 2018. They co-parented, they fostered a relationship, they continued kind of living as the couple that they were for the better part of nearly 3 years, if not more, planning a wedding, going to these events and these functions, attending at these events and functions as a family. I think it's a Halloween photo where it appears to be the Star Wars themed something, and everybody's there with a big smile on their face. This was well after 2018. Give you pictures of the father-daughter dance. Again, this is well after 2018. The recitals, the birthdays. There's one where my client's dressed up in a 4th of July outfit with his daughter clinging around his neck. Again, these are all evidence, contrary to what mom states, where he wasn't involved, that shows directly he was. I didn't give you the entire stack Mr. Stone provided me. We can give that to a GAL, even though I don't think that's appropriate. That's not part of our request, that are literally 2 inches high, just the pictures that he printed off and said, this is what I got to refute what it is she's saying. This child deserves a relationship with dad. Now, this child deserves a relationship with mom. The issue we have right now is that my clients just been unilaterally kind of, Joel, could you turn off your camera? The problem that we have right now is this child has just been unilaterally withheld from dad, and dad is a big source of her life who loves her and that she loves dad. And again, that's what this comes down to. We didn't file this as a modification. We're not asking it to be modified. That would require a whole different set of legal issues and procedure. We don't need that. We're simply asking that the existing parenting plan, now that he's met all the requirements of paragraph number 4, we're simply asking that the existing parenting plan be enforced. My client is realistic about this, and that was kind of the suggestion that we gave in anticipation of today. He knows that the court might not just say, okay, we'll go back to the parenting plan and bite the bullet, and it is what it is. He's suggested, and he continues to suggest what he thinks is going to make the transition easy. There's no doubt in his mind that this child will pick up right where she left off. There's no doubt in our mind that the relationship is going to continue to be strong. But for the next 4 weeks, we're simply suggesting weekly visits, one on Wednesday for a couple of hours, one every Saturday for several hours. The Wednesday visit will allow my client to take Ava to dinner, catch up with her, talk about her week at school. The Saturday visits will enable him to go to the park, have the father-daughter outings that he's enjoyed up until late 2021. Those types of things are important. And then in time, after the expiration of 4 weeks, we're asking that the existing 2018 schedule be re-implemented, which gives him the overnight visits. And again, in addition to those Wednesdays, that's what Judge Cruiser set forth back in 2018. And again, that parenting plan is problematic because it has never, ever been filed or been followed. And that's part of the kind of overriding issue that we have on this. Again, I think it's concerning to me looking at the response we get from mom, which just completely creates a different reality than the reality before you today. A very different reality than is set forth from the exhibits and the information that my client has filed on his behalf. And it goes kind of to the heart and the crux of this, which is who can you believe? And I think the information provided shows that, my client, despite his shortcomings, which he readily acknowledges, at least is before you with clean hands telling the truth, desperately seeking to reestablish that relationship with his child. Before I turn it over to Ms. Baldwin, I want to briefly comment on the evaluations. He initially went to Olivia Lovely for the domestic violence assessment, was met with extreme resistance. Now, that was a case in which we're talking about a DV finding that's nearly 18 to 20 years old. Ms. Ribeiro goes in there, gets her piece, and then my client is basically told, well, if there's an allegation of domestic violence, more than likely it happened, and we're going to recommend some kind of treatment.
Objects. This is pure hearsay. It's my client was told, or counsel was told, but these are elements of hearsay that I was planning to reserve, but once counsel's arguing off of them, this is just hearsay and it shouldn't be considered nor argued.
Well, that's fine. Well, I'll strike that from the record, but it doesn't take away from the point that he's got a different one from California from the same provider that did his 52-hour high conflict parenting class, who says, he's done what he's supposed to do. And we provided you with the information from that. There's nothing in that order that prevents him from getting a second opinion. There's nothing in that order that specifies where he's to go to. And the hard part is when there's only really one place in town that you can go through, and that's kind of where he was at the time. So again, he owns that. He gives a very valid, reasonable response to his decisions and what's happened during that course of time. But it all still comes back to those 3 years following the trial in which these parties operated together, and everybody was more than comfortable, Ms. Ribeiro included, in having the child go with my client and live as a family unit. And again, that's the important thing. Getting that reestablished and getting that back on track is in the best interest of this child, and that's what we're asking the court to adopt.
So counsel both argues that this plan was never followed, but then in the same breath admits that it has been followed since 2021 at a minimum, and my client would claim longer. So this has been the plan and the asserted plan for an extended period of time, even under their theory of the case. And with that, Mr. Still sat on his hands, knowing what he was supposed to do, just didn't do it. Didn't do it for years, even when they admit that this plan was being fully enforced. And that is par for the course when you see a case that went all the way to trial and a judge making findings of domestic violence and potentially even more critically, abusive use of conflict. I think that those both lend themselves to gaslighting, and that's what you really see happening here. My client denies that there was this extended reconciliation, and that doesn't make sense with the other evidence you have before you, such as my client's boyfriend saying that they've been together for several years. The text messages they say, prove it 100% are illegible. You can't read any data on there whatsoever, nor who they're even from and to. When you look at the pictures where he says that he's been so involved for years, there are pictures of the child graduating from Head Start, so age 4, prior to the trial. There are other pictures where she appears to be largely a toddler. The one in her Kelso, a cheerleading outfit, that's a 3 or 4-year-old. And when you look at the rest of them, they're sort of the same size child. This is a small child. He doesn't have pictures consistent with his statements that show he had all of this extended time for the next several years. He just didn't. He doesn't have pictures because he wasn't there. When you look at the only pictures he does have of the child in her sort of current age, they're ones at public events, such as the Christmas party. And I would invite the court to look at that photo. When you look at that photo, where is that child looking? She's not looking at him. She's looking down and away. Her face is pinched. That is not a child who's engaged and happy he's there. That's a child that is nervous and a child that is upset. And that's what you see. That's sort of the current status of their relationship. Specifically, there was a restraint against Mr. even contacting my client unless it was regarding childcare. And what you do see in some of the more recent text messages is a whole lot more communication that he's making at her, and a bunch of communication that's extremely inappropriate and exactly the abusive use of conflict that the court previously found. This idea that he's taken this class and gee, he's learned so much isn't borne out by the text messages that my client attaches, which include starred out curse words that he's making at my client, long paragraphs. And then you see my client's responses like, that's inappropriate, or sort of one word attempts to sort of de-escalate, and then another big paragraph from him. So again, we have a huge problem, and his story does not line up with the evidence before you. When we look at the 2 domestic violence evaluations, the court was very clear. A, he sat on his hands. He didn't do this for years. He finally goes to Olivia Lovely. She actually does have collateral contact with my client, and she does a thorough report. Everyone here knows Olivia Lovely's qualifications. So I won't belabor them, but she finds he has high risk factors. He's a problem risk for truth telling and recommends 9 months of treatment. Olivia Lovely didn't talk to the GAL. I would hope that she at least considered the GAL's report. Mr. isn't happy. He then shops for a sort of fly-by-night outfit out of the internet ether and finds a place down in California. This lady has no stated qualifications, no CV, no experience. She never sees him in person, doesn't talk to my client. Her report doesn't say anything about her ever reaching out to my client or her even having my client's information, doesn't see the GAL report. So essentially, based on self-report alone, even that provider says he needs 20 weeks of treatment. And interestingly, he's done neither. Regardless of whose report you're using, he doesn't do any sort of treatment, doesn't begin any sort of treatment. And again, that's out of compliance with the 2018 parenting plan that said he had to do the evaluation and treatment. And if he didn't, Judge Cruiser / the court would decide what to do about his failure. And the court wanted him to do those treatments because of how high conflict and how the domestic violence interplayed with the child and the child's needs. So even as we sit now, he is not compliant. Again, as far as visits, my client says, I really didn't understand. She's not a lawyer. This looks like 2 people that were not doing it with lawyers. So there wasn't a whole lot of anybody after the trial to explain. She said there was visits. For some period of time, they were sporadic. She said then she realized that she could sort of enforce the parenting plan. She started doing that. Visits stopped. He had essentially 2 to 3 random visits through sort of 2020, 2021. She details those. But visits where he's on a porch smoking cigarettes for a half an hour while talking to the child, not very appropriate. A Christmas party or Christmas event where he confronted them at the exit, essentially forced a photo and then chased them down afterward, continuing to talk about legal matters in front of the child. And then him having to be removed from the child's school because he's at the fence line and then exceeding the fence line, essentially breaching the perimeter of a primary school, and had to be removed. These were the actions, and again, high conflict actions that do not reflect someone who's learned any sort of lesson. So again, we're in a situation where this child really has not had any contact or significant contact with him for years. Now, my client's still trying to maintain some sort of connection. She's not the person who's trying to eliminate him. She's not trying to cut him out. And so she has allowed phone calls because those can be sort of made sort of safe. But what are the reports about the phone contact? That it's relatively brief, about 5-minute calls, maybe once a week, that he uses that time to talk about legal matters, to blame the mother, to upset the child, and yell at the child. And that's not only reported by my client, but by others who it's so loud that they can hear him yelling and see the child being upset. And again, these are upsetting for the child. A 9-year-old is not equipped to deal with this. They just aren't, and they shouldn't have to, frankly. We have, again, the text messages for him that are inappropriate, my client trying to de-escalate. So the court, again, for the parenting plan is to determine the remedy on what to do if the respondent has not complied. So in this case, our recommendation, again, we also aren't interested in modifying the parenting plan. We're just interested in him getting the help he needs so that he can have a safe and appropriate relationship with this young lady. We're asking that the court require him to begin treatment with Olivia Lovely, or he can find another provider in Vancouver or Portland if he so chooses. But it should not be this fly-by-night, no CV, no qualifications, internet. That's not appropriate. That is not getting him the treatment that he needs. Second, we're asking that there be no visits, no in-person visits until there's at least several months of DV treatment on board. Again, he was recommended to have a minimum of a 9-month program by Olivia Lovely. I'd like to see 3 months of him consistently being in treatment prior to starting any sort of visits. In addition, how far we progress and how quickly they progress, I do think a guardian ad litem is appropriate to talk to the child, to get more information, and make a better assessment on how we progress forward. And then in addition to that, it's just important that we keep the child's best interests in mind here. I understand that the respondent just wants to say, hey, look, I've done it. I've checked that box. But A, he really hasn't. And B, he waited 5 years to do it. That's an eternity in a child's lifetime. It just is. Finally, we are asking the court to assess fees in this matter. We're here because of the respondent. He is the one that sat on his hands and waited for years to do the assessment and still hasn't done the treatment that not only Ms. Lovely recommends, but even his chosen DV evaluator recommends. So we are asking for fees. I'm asking for $3,500. My client does not have a lot of funds. Again, that's why this was, I think, pro se to start with the first time. And so I think that that's a reasonable amount considering this hearing and the fact that we're likely going to have to engage in at least 1 or 2 additional hearings. So given that, we're asking the court for that relief.
Okay, so and I think we all agree this isn't the greatest parenting plan that's ever been written here. So, but I want to just ask everybody's opinion here. So I'm looking at page 2, section 4, where it says limitations, and the 52-hour online high conflict co-parenting course. And that's through and there's a website there, the courtorderedclasses.com. And then domestic violence evaluation with collateral contacts. And then start or continue and comply with treatment as recommended by that evaluation. Provide copies of those evaluations. And the child care, that's not, so my understanding, and I guess, so first question, Mr. Zandy, the second DV evaluation is from that same joint. Is that correct? Okay.
Correct.
And then either, and I'd like to hear from both of you potentially if there's, it sounds like Ms. Baldwin believes all that needs to be completed before the parenting plan kicks into place. And if that's wrong, Ms. Baldwin, please correct me.
So he was supposed to have the evaluation with collateral contacts. What's challenging is that down below, it doesn't have any lines, but just above 5 decision-making, Judge Cruiser was supposed to review this in 3 months to essentially make sure everything was on track. And so my assumption is she was going to assess sort of what to do with parenting in that review hearing that maybe happened, maybe didn't. And similarly, she was to decide, or the court was to decide what to do with non-compliance. So I think that the court can allow contact because he's completed the 52-hour class. What that looks like moving forward, I think, is the court's determination based on what this order says.
Well, part of the issue with that argument fails on a couple of reasons. Number one, you've got that built-in provision that it's reviewed in 3 months with Judge Cruiser. Again, not contemplating that they're going to go back to living as a couple. And if he was such a violent, terrible monster, why would she want to be engaged and get married to him in Hawaii 3 years after the fact? That's part of the issue. Second of all, to that, there's nothing in here that I can see. You got the limitations on the parent, and basically it just says, again, interlineated by Judge Cruiser, father is restrained from contact with mom for any reason outside of childcare. We know that as soon as they got outside of court, that went by the wayside. And then it said if he doesn't follow the evaluation or treatment required above, then it's to be determined by Judge Cruiser. There is no nexus or parallel between paragraph 4 and paragraph 8, which is the parenting plan. She's not saying that until he does these things, he gets no contact. And then once he does these things, he gets this. They're different from each other. This is saying that this is the visitation plan. He gets this regardless for the next 3 months. And then we can come back and look at where things are after that point. So it's contrary then to the argument in which counsel said, well, we just want you to follow Olivia Lovely's recommendation. That again doesn't account for the fact that they were together nearly 3 years after the trial. And it also doesn't comply with what the existing order states from Judge Cruiser. That was the point of the contempt back in the summer at which Judge Scudder didn't sign the order to appear. I think based on that fundamental misunderstanding of that. Those two are not, they're connected obviously to the same parenting plan, but one is not dependent on the other. She's giving him the visitation, she's giving him that right. She's just saying, once we come back in 3 months, we'll see where things are at. This whole entire time, my argument would be he should have been getting every other weekend, Saturday overnight to Sunday. He should have been getting every Wednesday night. Thus, the motion for the contempt last summer. To suggest that he has been sitting on his hands cannot be further from the truth. And this is a guy who has done stuff on his own initiative, pro se. He sought out these services. And we've got 2 letters of completion and certificates of successful completion from the outfit who did the domestic violence evaluation, plus the high conflict parenting course. If one's good enough, why is the other not? So again, if you look at it in its totality, I think that's where that argument fails on a couple of different levels.
The court here specifically, the last line is what happens if he doesn't comply? And it basically says the judge decides. So the judge does in this case, or the court does in this case, have the power to determine what happens, including what happens to his visits.
Well, what happens if they get engaged to be married in Hawaii? They live together as a couple. That's the problem that we run into.
Okay, so this is a kind of an interesting situation here, and I will say this: I agree with Ms. Baldwin. Some of the text messaging and things were hard to kind of make out exactly who and when those were sent, but does appear as though that there's been collaboration between the parents more recently based on some of the messages. I'm not going to even begin to try to assess how old a child is based on a photograph because I would lose at that game. But I understand the concerns. I also am very much for a child having access to both of their parents, especially parents that want to be actively involved in their lives. I do show, so the 52-week program as ordered on under the first section of part 4 in the original parenting plan from 2018. That does appear to be completed, and it was completed through the place that's listed in the parenting plan. The second part, we do have 2 different evaluations for domestic violence, one with Ms. Rivario's input, one without, and neither with Ms. Wright's input. As we kind of established at the beginning, Ms. Wright is no longer a GAL and isn't even working in the local area. So that not going to necessarily hold that against Mr. Stone, especially if, it does appear to me that they probably were not following the plan for at least a period of time after this was entered. I'm not going to make a determination how long they were potentially together after that, but it appears that there was some collaboration, as I stated. I do note that there is some recommendations for some follow-up treatment in those evaluations that were completed. So I'm going to ask that that be followed. I'm not Frankly, if the high conflict co-parenting course that was done, the 52-hour high conflict course was sufficient, I'm going to allow Mr. Stone to determine where he does this additional treatment. Obviously, it probably would be beneficial to either start with one of the places he had the evaluation, so he doesn't have to start all over again. It does appear to me that based on this parenting plan, that's something that needs to occur. Now, determining whether the parenting plan kicks in after all that's done or while all that's happening, there's no real clear-cut answer on this parenting plan. I understand the parents or mom's concerns. I understand dad's concerns. So what we're going to do, I guess, and one thing that Ms. Baldwin threw out there that I didn't hear from Mr. Zandy was a request for a GAL to be appointed. Do you have a position on that?
I just assume not, and I do have some. I'm not going to be opposed to it either way. I mean, there's benefits of having a GAL appointed to look at this. That would be fine. My only concern would be if that would be granted again. If this was your typical modification action, I think it's a no-brainer. This case would warrant it. The fact that we're just kind of in on a makeshift motion to enforce and kind of trying to do the best we can with what we have from 2018. My fear is that a GL is going to come in and reinvent the wheel or change things or and I don't know that we can do that statutorily under the RCWs. That would be my only concern with that.
Okay. Well, here's what we're going to do. We're going to do kind of a few phases here. What I'd like to see, because it sounds as though there's not been any one-on-one contact except for over the phone in at least a few months. Is that fair?
That's fair.
Okay. So I'd like to start with some supervised visitation. I don't know if the folks have someone that they would feel comfortable with that isn't a professional, or if we need to go the professional route. But what I'd like to see is a handful of supervised visitations and a report back on how things are going, how the child's feeling. And then from there, kind of determine if there's a need for a GAL. If things are progressing fine and there don't seem to be any problems or major issues after visitations, then I'm less inclined to think a GAL may be necessary. I don't know if that was even something contemplated by the parties. If if there may be an unprofessional supervisor that can fill that role, or if you would like a chance to chat about that.
Well, because the court wants reports and wants to base things off of those, I'd probably recommend a professional, because Mr. Zandy's, whoever Mr's family picks, the claim will be biased for him. Whoever my client picks will bias for her. It's, I think, just cleaner if we just have somebody that doesn't sort of belong to either camp.
That's probably
I would just say
fair.
that my issue with, sorry.
No, go ahead.
I would say that my only concern with the professional supervised setting is, number one, it's very clinical. I think it's very sterile, and we've got a 9-year-old child here. And second of all, and probably more important, is the fact that I can speak from other cases. Again, we're kind of hamstrung with only having one agency in town who really does that through reconnecting families. And I know they are weeks out sometimes. And I don't want my client to be subject to availabilities, which might not be able until June. I mean, it's been long enough.
I know Tanea Gravina has done community visits, and she's on the GAL list. So that's an option, is that those can sort of satisfy both of those as more expedient and in the community.
Here's what I'm going to do. This is hopefully doesn't upset every single person here, but can we set this to next Tuesday to see what and I agree with Mr. Zandy. I don't want this to be 3 months in the making. That would obviously give Mr. Stone an opportunity to get treatment underway, but I don't want to delay visitations if possible. If Mr. Zandy, you find that either Ms. Fellows' place or Ms. Gravina is not able to help in a timely manner, or you can get one visitation next week, but the next one won't be for 7 weeks after that, I want to know that because I don't think that's appropriate. And so I probably will change up what we do. Is that something you can find out in the next week?
Yes, I can. And although I'm skeptical of this, I think if we could also arrange some kind of visit, maybe if there was a neutral third party, that would be beneficial as well. And I know my client has some ideas on that, and I do too, but I think we need to discuss that.
I'm not. Yeah, I wouldn't be opposed to that. I understand Ms. Baldwin's point, and it does make sense. But we do have those new handy forms now where they're swearing to follow all the rules and report any concerns. So if there is a mutually agreed upon supervisor, I'm not opposed to that. Mr. Stone, you're represented by an attorney, so he can talk to you.
Put your hand down. We'll be able to address it next week.
So feedback from that, I don't want to otherwise delay it. I appreciate that the phone visits are being allowed to occur. I would hope that those can continue. I would remind the parties to act appropriately in front of the child, no disparaging comments about the other parents in front of the child. But essentially, I'm inclined to kind of work towards revamping up regular visitation per the parenting plan, assuming there aren't any new concerns and that everything that was previously ordered is being at least worked on. And I would state most of it is.
So with that order, the only question would be, we have two different evaluations with two different recommendations. Essentially, Olivia Lovely recommends 36 weeks of treatment. The one with no collateral contact recommends 20 weeks of treatment, which is the court ordering.
I thought he could choose I thought he could choose. So
the court said he could choose where.
The one in California.
Right.
And I'm going to let him choose where. And just to make it interesting, I'm going to ask for a minimum of 25 weeks or sessions, I guess. However, it's just so it's not determined just by the easier one. And that obviously, if Mr. Stone wants to go to even a third place that's in person, that in Vancouver or Clark County or Lewis County that may be available and wants to take those evaluations with them and start fresh, that's fine.
Okay. So we'll come back next week, try to hammer out the specifics on the visitation and the contacts. But in the meantime, we'll start putting together a list of potential non-professional supervisors and put this in motion.
Yes.
Okay.
All right. And then, like I said, that'll determine if we think a GAL is needed. Obviously, that can be renewed by either party if there's any issues that arise as we progress.
And I won't present an order just yet. I'll wait until next Tuesday when we get a little clarification on the supervision stuff. Is that fair?
Gibson, I'm looking at the
I think
order
that's fair.
for relief.
Okay, thank you.
All right. And this
Yes,
was
ma'am.
the attorney's fees being reserved, which I ordered, and then the child support being paid back at the $538.72 at $125 per month minimum. So I'm
Yes,
going to
ma'am.
sign that order as well.
May I ask, I apologize. May I ask one clarifying thing regarding that document?
Sure.
Okay. So I was provided with the order for relief. On the second page, it has the court orders. Number 3, which was the sale of real property, you're reserving on, in that hearing, you reserved on the issue of selling the home, and we're going to review it at the May 16th hearing date. It says that I need to establish that I can refinance the home. I just want to clarify with the court that that's not me having gone through with a refinance. That's just providing proof that I qualify to refinance the home.
That is my understanding and what I was ordering. Yes. So I'm not expecting you to have a refinance done by then, but proof that if we were to take over that home, that you would be able to do that.
Okay. Thank you, ma'am.
So then I do believe I saw some filings or correspondence regarding some of the additional requests for discovery and the compel order. Does any of that need to be addressed today, or are we going to? Okay.
So,
all right. So Ms. Baldwin, go ahead.
thank you. Everything we've talked about was regarding the first discovery request and the first motion to compel. Now we're talking about an entirely different discovery request and a motion to compel regarding that request. If you look in Odyssey, because the request is not overly long, we actually just filed a copy of the entire thing so you can review it. That was attached to the reply. So in this case, regarding the second discovery request was largely focused around obtaining communications between Ms. Gibson and her boyfriend, and as well as her family who provide supervision or who have provided supervision for her during this case. Unfortunately, the response back was incomplete. It was misleading. And other things were objected to improperly. Sort of a common refrain from the respondent, will supplement, but she never does. The court will recall from the first request, she wrote will supplement in 2021 and then never did. Her responses here are the same, will supplement, I'll look into it, but there's never any action steps. I've ordered it, I'm printing it, I'm getting it. It's just a delay and a stall. Again, the communications are important that we receive those. This is the boyfriend who lived with her and that she hid from over a year from the court and the guardian ad litem. The boyfriend was court ordered to not have any contact with the children of this case because of the level of danger that he represented. He wasn't allowed contact with his own children. He had significant felony history. And so we're seeking the communications between the two of them, as well as, again, how much her family and friends participated in sort of this ruse to both the court and the guardian ad litem as well, because there'll be arguments at trial about whether or not they can safely provide supervision for her. The requests that we have made are largely sort of point and click type of requests that she can fulfill very, very easily. We've given instructions on, click here in Facebook, go there, click this, and you can download a file that has all that information. So this is not difficult information to obtain and procure. Unfortunately, not only has she not done that, she's also provided what I would argue is falsified information. We attached the sort of phone log minutes that she provided saying that she has satisfied that request. Again, you see that minutes is misspelled. That indicates to me that that's not likely an original document. This is something that she's doctored and provided. So again, she's doing that to mislead the court, but also to mislead the guardian ad litem. She's providing the same information to the guardian ad litem saying, gee, I really haven't had communications with this fellow. Look at my phone records, when again, it doesn't look like these are genuine. So again, in this case, it's very important that we receive the actual documents. When you look at the objections that she has made, the objections that she's made are improper. They're clearly objections for a personal injury case. She's essentially taken something from her office. She happens to work in a legal office, cut and pasted that into her responses, and that is her providing them. She says, this X or Y isn't time limited. Most of these are time limited, or if they're not time limited, they are point and click type items that it's just, it isn't burdensome. Unlike so many other things, some things really aren't burdensome. For text messaging, she's, oh, gee, I can't provide it. In our response, we provide there's 10 plus places that can provide this information, again, through sort of a point and click type of process to make it very easy. So her arguments really fall flat. We're asking that she be required to provide the information. It really is critical information for the case and ultimately to the safety of the underlying children. Finally, we're asking for fees for being here. I'm asking for 3 hours of my time. That would be $1,425. The objections are meritless. We've gone round and round with her. I've done CR26Is trying to give her opportunities, and she provided falsified information. I think that warrants fees and potentially a sanction.
All right, thank you.
Thank you, Your Honor. So I received these from Ms. Baldwin's office. As she stated, some of these requests don't have limitations on them. Specifically, that very first request for production wants a complete archive of my Facebook account, of an Instagram account. The Facebook account, as I put in my responsive declaration, I've had for about 20 years. I don't believe it's reasonable for Ms. Baldwin to need 20 years worth of information. During our CR26I that we had regarding these things, I asked her, I stated to her, I don't believe this is reasonable. I asked that you reduce it down to something that's more reasonable, more manageable in relation to this dissolution. And I didn't get any response. That it was just, it is what it is. You point and click and get me the information. I'm happy to provide her with that information. I just ask that the court limit the length of the information that I give her. Again, I don't think specifically for the Facebook account, 20 years worth of information is relevant to these proceedings. And again, with regard to the text messages, I didn't know of a way to get her the, as the request states to get a electronic native copy of information other than taking a bunch of screenshots. When I asked Ms. Baldwin during the CR26I, she said, oh, there's lots of ways you can get that information. I asked for an example of one because I didn't know of any, and she didn't provide a response. However, in petitioner's, responsive declaration, he lists a handful of different programs to be able to obtain that information. Had Ms. Baldwin's office provided me with that information before this, I could have potentially fulfilled that request. Also, that it doesn't narrow, I apologize, it doesn't narrow who she wants communications from. As I put in my response, I communicate with my phone, with my family, with friends, with my coworkers, and with my employers. This request for production the only thing it excludes is attorney-client privileged communication. I don't believe that communication with my coworkers or communication with my employers, communications with my friends outside of the friend who is the one of my supervised visitors, I don't believe that information is relevant. Again, I asked Ms. Baldwin during the CR26I if she would limit that information, and I didn't get a response. So I held to the objection. Regarding, the objections, I'm doing the best that I can without representation. And I felt like the things that I objected to me made sense. There was, I feel, a lot of invasion of the privacy of the people that I communicate with. Had there been a request stating the individuals that she wanted information from, I could have, thought about and made an assessment based off of that. But this doesn't state that. It states that I can only exclude attorney-client privileged communications. So I just ask that if Your Honor is going to order that I produce some of these things, that there are limitations on the people who she wants information from. A lot of my friends I don't communicate with regarding this. If she wants things from my sister and, as I said, my best friend who are currently supervised visitors, I will happily provide that information. That was not indicated to me in the CR26I. That's not indicated anywhere in either the motion or the response motion. And so I just need some more clarification on what to provide. The other thing that I would like to address is the production of what she calls these doctored cell phone logs from AT&T. I cannot be responsible for how AT&T imports their information. As soon as I received the responsive declaration from Mr. Gibson regarding this, I immediately went onto my AT&T account and pulled up my most accurate phone log to see what indeed was going on. I downloaded it as I am able to based on my AT&T account information. And that is how the log pulls the word minutes in. It's very incorrect. I noticed it the first time that I, provided the logs to the GAL. I didn't change the word minutes because I didn't want Ms. Baldwin or anyone really to misconstrue thinking that I, messed with the logs. So that's an error on AT&T's part. I don't know if it's a coding error. I don't know what the issue is, but that's how the logs gave themselves to me when I went to download them. So the fact that there's an allegation that I doctored these logs without any proof, just stating that I've doctored them or made them up, created them, I feel is really baseless, and just trying to throw something out there to try to mislead the court, stating that I'm misrepresenting what's going on. When the court ordered the switching of custody and the girls went to petitioner back in November, you can see it on the phone logs. Like, there's no more communication. There were a couple of phone calls after that hearing date in November, and that's it. Because I'm following what the courts asked me to do, and I provided those phone logs. So for petitioner to state that I falsified them without, or just doctored them completely without any proof, is baseless, and I don't believe should be considered by the court. I ask that the court not award attorney's fees in this matter today or reserve on them. Again, I asked Ms. Baldwin for better clarification. I asked her for specific communications that she wanted from the people in my life to get these requests to her, and I didn't get any conclusive responses. So I held to what I had provided to her office.
Okay.
Just in responding to the reply declaration that petitioner submitted, interrogatory number 4 that was requested from Ms. Baldwin's office wanted me to state the social media sites I used within the last 5 years. I stated at the end of that objection what sites I used. So petitioners claiming that I objected and that I didn't apply and I didn't identify appropriate platforms makes no sense, because it's right there that I put at the end of my response to that answer. Interrogatory number 5 wanted text messages, which again, I provided to the GAL per the GAL's request of what she needed per that court order in November of 2022 for her to look into any, quote, continued relationship with Mr. Rosales. I provided the phone logs that she had requested, petitioners claiming that I've doctored them and that I created the document simply because the word minutes is misspelled, but there's no supporting documentation to prove that, stating that I'm falsifying evidence, which they provide no proof to the contrary. And the only other thing is, there's only one response to these interrogatories and these requests that I stated I would supplement. And that one was the request to have all communications from my attorneys with the GAL. And I had to state that I would supplement that response because I didn't know what or if my attorneys had any communications with the GAL. I couldn't provide a time frame on which to produce those documents because I didn't know when those attorneys would have an opportunity to get back with me. And in my responsive declaration, I attached the emails that I got from both of those attorneys regarding that request. So the claim that I'm purposefully trying to keep people in the dark, or that I'm just trying to make things delay and last longer, just simply isn't true. That's the only response. The will supplement response was the only one. And that was simply because I didn't know the time frame in which my former attorneys would be able to get back to me to supplement that information to Ms. Baldwin's office. So again, I asked the court if they are going to order that I'm required to provide that information to Ms. Baldwin's office, that it be limited as I've stated in my responsive declaration, and not to enter attorney's fees at this time. Thank you.
So the request was made back in early February. We don't even see her attempting for the first time to obtain the information sought until March 30th. So basically, I'm not going to do anything. I'll wait until the motion to compel, and then I'll start filing. I'll start a request at that point. So again, I'm going to sit on my hands. I'm going to delay. When you look at the requests, all but essentially 2 of them are time limited and fairly time limited. Year and a half since 2021, since 2020. They're looking really at the last primary 3 years. The only ones that are not are really the Facebook Meta group, because it's the easiest to, frankly, obtain the full record. A little harder to parse it out, frankly. Again, this is a total of just 5 substantive interrogatories and 5 requests for production. On several of these, she admits, well, I'll provide this, but she hasn't. So she admits there are things that are appropriate and that she shouldn't have provided. And not only has she not provided them initially, she doesn't provide them after the 26I, and she hasn't provided them still. So again, even though I admit I should provide it, I'm just going to continue to withhold that information. Relevance is not the standard for discovery. That's the trial standard. The discovery standard is much, much more broad. And again, it's appropriate, it's she doesn't even claim that she would be embarrassed by these communications. It's just, I don't want to. And that's not an appropriate objection. She doesn't deny that her legal objections are meritless. So again, in this case, even though she admits that there are many things she should have provided here, she has not done so. She continues to withhold them, and improperly so. We have a guardian ad litem review coming up next month. And again, the concern here is that a big question is, how long was she hiding from the guardian ad litem this relationship, and what did this relationship look like, and what role did her friends and family take in hiding that, during the time when he was barred from having contact with the children. So this is relevant information, even though that is not the standard. So again, because we're here, this is the second time we're having to be here on a compel, I am asking for some substantial attorney fees. And in order to compel, we can review on that same date as we previously set forth.
I think Ms. Baldwin did make a very good comment here that the relevant standard does not apply to discovery. I would clearly make rulings on whether some of these, a Facebook message from 20 years ago is relevant. Arguably, I mean, we may all be able to agree that that probably isn't, but you don't know. And generally, the court doesn't get real involved in the specific requests of one attorney on behalf of their party to another party. Starting to go down that road and deciding what's appropriate, what's not appropriate, parsing out some requests or limiting certain requests or making rulings on certain requests is kind of, frankly, I see it a little bit as a slippery slope, because I guess I wouldn't want to set any kind of precedent that, just go to the court and the court will limit what you have to turn over in discovery as part of a dissolution. So I'm a little cautious to do that. I have reviewed the attached, I think it was Exhibit A as attached to the reply declaration. That is the very specific, here's what we're asking for. And I read through each request. Obviously, apart from the Brian Rosales portion of that, the court feels that none of these are trick questions, or I think how overbroad they are isn't relevant at this point in time. And so I'm gonna grant the motion to compel. I'm not going to limit anything that's in there. I understand Ms. Gibson is wanting some parameters or clarification. I would hope that Ms. Baldwin's office would work with her on any of those clarifications. But I'm gonna set a limit on this. I know we have one deadline coming up next week for the first set of discovery. If we have our next review on the 16th of May, I could either set the 28th or the 5th for those to be provided. I just want to make sure that all parties have sufficient time to get that done and to review what they receive.
I've asked for that to be April, was it 28th that you're proposing?
Yeah, and I don't know why I'm picking Fridays. I guess it doesn't have to be a Friday, but
yeah, April 28th is fine, because again, a lot of the information goes into what the GAL would need to have received. And so that's why I'd like it to be the earlier date, because then if we need to push out the GAL's review, then we can address that. There's time to essentially then address that.
2.5 weeks from now, close of business, all that needs to be given to or responded to with information, the supplemental information. I'm not going to make any kind of finding that the phone records are falsified at this point. Ms. Gibson, if you have, I'm not expecting you to, take extra steps to prove that, it is what it says it is. But obviously, if there's another way to show that information, you may want to do that. But I'm not making a finding that they're, falsified. I understand the concern. It does look a little different than a lot of the phone logs that we do get, but so everything by the close of business on the 28th, and your half days on Friday, is that correct? Did you tell me that last time?
I am not half days on Fridays. We're
Okay,
open till
so close of business on Friday, the 28th. We'll review everything on the 16th. As to attorney's fees, I understand the request. I also understand Ms. Gibson's likely frustrations of having to navigate this on her own. I think we have some I'm going to reserve to the 16th. So Ms. Gibson, if you do everything that you need to do and we get everything completed, I'm going to take that into consideration with regards to any imposition of fees in this case. So those will be reserved, and I'll hold the request for that 1425
Ready, Judge.
over to the 16th of May at 1 p.m. Oh, and looks like Mr. Jones, are you jumping in on this one?
I am, yes, I'm here for Mr. Furlong.
All right. I didn't see a notice of appearance. So were you aware, Mr. Zandy?
Yeah.
Mr. Jones and I have had a couple of conversations, I don't know, over the last couple of weeks. So I knew that he was involved in some capacity. I didn't know that he was going to appear today, but that's fine. I would just ask that we get a notice of appearance so I know who to ship orders to and pleadings.
I told Mr. Zandy I was hopping on the case and asked him if he would accept service. I'm not sure what's unclear about it, but I will file a notice of appearance.
Perfect. And we are on for temporary orders.
Correct. And for the record, I do represent the petitioner moving party to the motion before you today, Judge, namely Betsy Furlong. And I think the pleading set forth kind of pretty specifically what the issue is. So we've got 3 very young kids. We've got Lucas, who's 3, and we've got twin boys, Declan and Julian, who are a year old. This is a case in which the parties had filed initially about a year ago. They reconciled for a period of time, and then come December, I realized that was not going to work, and my client has refiled for the dissolution action. Many of the same issues have been prevalent. A lot of those are unresolved. And again, I think those are laid out in the declarations, not only from my client, but as well as the lay witness declarations on her behalf, as well as kind of a taste or a sampling of the issues she's had over the past couple months at least, but those have been ongoing throughout the relationship, but unfortunately getting worse. Number one concern is with the care and support of the children. Again, this is one that it seems undisputed that my client has largely been the primary caretaker, especially since the twins have been born. She's been the parent to stay home with them, to take care of their day-to-day, minute-to-minute functions, which is, the feedings, the bedtimes, and the like. Mr. Furlong has indicated that he's an involved parent. We certainly don't dispute that, but to the degree of which he has depicted that, again, I think is somewhat disagreed, or at least referenced by my client, that she just doesn't think it was nearing the degree or capacity in which he states in his pleadings. You look specifically at where we are today, and I think you need to go no further than the communications between these parties and the text messages that have been provided. This is one in which Mr. Furlong's general demeanor has been, yeah, we'll do whatever I want to, and you're kind of along for the ride. That goes towards parenting, that goes towards living inside the home, that goes towards finances. And basically he has attempted to run roughshod over my client and all things pertaining to those kids. It's the first time I can remember that the parties had, again, due to dad's choosing and dad's, again, demeanor, actually had to abide by a parenting plan in which everybody lived in the same home. Everybody currently is residing in this Pear Avenue home. The boys are there, my client's there, and dad comes home from work, and he works typically Monday through Thursday by design, his own design. Dad comes home and says, okay, your services are no longer needed. Essentially run off and make yourself disappear, lock yourself into a different room, and it's my time with the boys. Again, that's highly inappropriate. Now, my client details for you kind of this, what she terms as a toxic environment. Obviously, that's promulgated by many of these types of responses and these types of dictations that come from dad, basically saying it's my time, get lost. Causes confusion, especially for Lucas. He's 3 years old. These kids have spent all day with mom. Mom's essentially relegated to some kind of inferior position in the home once dad gets home. And kids want to see both parents. Kids are used to both parents, especially seeing mom throughout the majority of the day, confused as to why she's no longer available. Dad then takes that a step further. Essentially, nope, when I'm home, you need to make yourself disappear. That's problematic. That's first and foremost. That dovetails and goes with a lot of the concerns about the property, a lot of the concerns about the communications, and a lot of the communications about dad, and not just telling my client, but also other third parties, including my client's parents, how things are going to be. He states for her, and again, this is just a sampling of the text messages, in no uncertain, threatening, and demanding tones. The house is mine. You need to leave. Here's the day you need to leave by. If you look at the language of some of these and you look at the tone of this, again, it's unusual for anybody, let alone somebody who's a mental health counselor, to use these types of expressions with their spouse. But that kind of gives you, again, more glimpse into the toxic situation that my client's undergoing. He states in one message that she needs to move out of her bedroom no later than 8 p.m. on Sunday. He goes on to say if she needs to live out of a motel until you guys, meaning my client's parents, have a better plan that can be an option for you. And he states, I'm happy to keep the boys for an extended amount of time until you guys know more, but I will not budge any more than I already have on the day Betsy is to move out. So he's speaking not only to my client, but her parents as almost an authoritative figure, as almost a parenting figure to my client and her parents. And then we wonder why this is now the second time in less than a year that they've been separated. That's problematic. That bleeds over into the relationship with the boys. Again, Lucas, the 3-year-old, sees this. Lucas was confused when his dad, in his very close proximity, calls his mother the C word in front of the child, who appears upset by that. This is the same environment in which dad takes my client's phone, her keys, he blocks her car. So we have this push-pull back and forth of him saying, you need to leave under my terms, but if you try to go, I'm going to take your phone, I'm going to take the keys, and I'm going to block your car. And again, this is all evidenced in the text message that my client provides. This is evidenced in the communications and the declarations that were provided from lay witnesses on my client's behalf, one of which came from somebody who's not even associated with, was a contractor doing some work on the home, in which she states, yeah, both parties love the kids, but dad is not only inappropriate to his wife, but also the people who are on site as well. So you have this kind of this demeanor from dad, which presents as a bully, and you get that from the communications. And the surprise to me was in reviewing his responsive pleadings and his declaration, he doesn't really deny any of that. He doesn't acknowledge it much, but he doesn't really deny it. He refers to all of his efforts. I did this, I did that, I planned this, I took the boys to X, Y, and Z. I am pretty much the decision maker and the shot caller in this relationship, and everybody can just deal with it. That's the mentality that's dangerous to the kids. And anytime a 3-year-old sees these types of things, anytime a 3-year-old hears his father call his mother that word, which is the word to call somebody if you're upset or angry, again, is extremely problematic. Moving forward, what we're suggesting on the parenting plan, I think this case is ripe for a guardian ad litem to be appointed. I think the issues are such that we do need to get a little bit of insight on this and a recommendation as to what's going on. Doesn't seem to be any dispute that since the twins were born, my client has been largely the one that stayed at home with the boys and cared for them. Mr., although he presents some kind of information, I was confused as to what context he was hoping to get that across, did go and apply for the family medical leave. That's great. That's undisputed. But on a day-to-day, moment-to-moment basis, my client's been the one who's taking care of these kids. He now expects her and dictates to her that you're going to move out. You're going to move out with your parents, just ignoring the fact of the burden this puts on the maternal parents. Maternal parents are not equipped to take on my client with 3 small boys. That seems completely unrealistic. That also diminishes my client's role with the kids. And most importantly, it diminishes the best interest of these children. We recognize the fact that my client has been the primary caretaker for all 3, especially over the course of the past year. Why are we uprooting the kids, putting them in a home with grandma and grandpa, knowing that they're going to have to transition once again later? And the answer to that, I think, is clear. In the text communications and Mr. Furlong's own responsive declarations, it's because it's his world and everybody's just supposed to comply with whatever his desire is at any given moment. And again, I think that's borne out by the information in front of him. He is an involved parent. We give him that. Now, he does have a relationship with the kids. Again, that's great and positive. We want to preserve that. I think the parenting plan that my client has proposed makes the most amount of sense, given the fact that dad works Monday through Thursday, given the fact that my client wants to start going back to work in a part-time capacity here very soon so that she can have some financial resources for herself. The plan is that she will work every Friday. Again, the plan makes sense. What we're proposing is that dad has the kids Tuesday night for a couple hours to give mom some respite. He can take them to dinner, to the park now that the weather hopefully will start getting good soon. Have them for a few hours, return them. Again, they can sleep in their own beds, and then have the kids every Thursday overnight from 4:30 to Friday at 5 o'clock. And then on the other alternating weekends, every other weekend, the parties just rotate that. The result of that is dad would get long weekends every other weekend, Thursday to Sunday. He would also get every week, Thursday overnight to Friday, in addition to every Tuesday for a couple of hours. Given the kids' ages, this is a lot of back and forth with mom and dad, but it also preserves the fact of recognizing, these kids' primary source of comfort, and that has traditionally always been mom. Relates to finances, and again, I think this is, it kind of gets down to what Mr. Furlong believes is best in his interest. It's a case where he's admittedly working less than full time. He's working 32 hours per week. Now we understand that that's $32 per hour, and we've imputed that and just taken the 32 times 4.3 to come up with his monthly gross income of about $4,403. In addition to that source of income, these two also have significant assets in rental properties throughout the area. In all, there's 8 of them. There's some dispute. Mr. Jones and I can probably figure out where the truth lies on what is being generated from income on those through discovery, hopefully soon. But at the end of the day, they're getting income from that and is being generated from it. What we're asking for is that my client remain in the family home. Despite him packing her belongings and putting them on the porch and saying, you need to get out, come get it, it's according to my timeline. We don't think that's in the best interest of the kids. We also think that creates some financial turmoil down the road for the boys and specifically my client, because they're going to be essentially moving twice at that point. And that makes no sense to do that to the primary parent. What we're asking for is that my client reside in the family home. The court give Mr. Furlong 30 days to move out. He's had ample notice of this motion. He's had ample notice of the request. Hopefully he's taken some steps to at least be prepared for the chance that he has to relocate as we're asking. We think 30 days is appropriate. They have all these rental homes. I don't know what the contract situation is or the leases with the current tenants, but nonetheless, that is an option. His income, it makes him more viable candidate to lease a place than my client who doesn't have that income. So him getting alternative housing is much more practical than my client doing the same. What we're asking is that the rental income go to pay the Pear Road mortgage first and foremost. That's a sizable mortgage payment on that home of about $3,500. They've essentially taken money out of one rental home, they've borrowed against another, and they've come up with this Pear Road, which is obviously the extravagant bill that they have to pay every month. After payment of that Pear Road mortgage, any remaining funds or proceeds from the rents should be divided equally. We think that's appropriate. By our math, and again, subject to change upon discovery, that would leave each with about $1,100 out of those rent proceeds. And we're willing to base the child support and the financial support thereafter just based on his income, which is that 4,403 gross, and my client's imputed rate of 1,800. And again, that's a significant benefit to him, and I think that works alternatively best for the kids. Lastly, we are asking, second to last, we are asking that the rental home, and I didn't see any objection to this in Mr. Furlong's pleadings, but we're asking the home located on North 14th in Kelso be listed for sale. We believe that's worth a rough estimate of about $155,000. I think we're all aware that rates have changed. The market is bound to change. It's our suggestion we list that home for sale in the near future and to maximize whatever we can get out of that. Both parties split that 50-50 so that they each free up some source of money. Alternatively, it goes in either Mr. Jones's or my trust account, and we divvy up whatever we can to give them some money to get established for themselves, get them through this divorce, pay their legal fees, and the other expenses that certainly go along with that. Again, that makes sense. And I didn't see any objection to that, so I'm assuming that that is agreed. And then finally, we are asking for a request of attorney's fees and costs in the amount of $2,500. My client simply does not have the finances on her own to continue doing this. She's had to have help from family to pay the retainer and to get through this. And early on, this looks like this is going to be a case that is going to take some work through a GAL, through a discovery, and ultimately hopefully put us in a position where we can divide the properties, figure out what we're going to do with the kids and the support issues and be done. But unlike some earlier cases, I don't think this is going to be necessarily a real simplistic one. We are asking for a contribution of fees and costs, whatever the court does find appropriate. We're asking for a date certain to have that paid by. My suggestion is within 60 or 90 days of entry of the temporary orders, and the GAL be paid for whatever the percentages work out on the child support worksheets that we have submitted.
Mr. Jones.
Thank you, Your Honor. I'll start with the house issue. Mrs. has not lived in the house since March 10th of 2023. So she's been out for about a month. It was not at the bequest of my client. She, in fact, volunteered to move out. Originally, the plan was for her to move into the house in the Cloverdale house. That is the house the parties lived in a majority of the marriage, and the kids have lived there a majority of the time. So if that plan had come to fruition, mother would actually move back into the house where the kids know the best. This Pear Road home is a recent home. So the plan was for mom to move back into the Cloverdale house, which is actually her home, I believe, prior to the marriage. So it makes perfect sense to her to move back into that home. She's already moved out all her stuff voluntarily. She rented her own storage space to move stuff out. The text message even show her telling my client, "Hey, this is my main weekend to get stuff out. I'm back on February 16th. This is going to be my main weekend to get things out of here. The weekend after I have the kids. Will I have your cooperation to get things out? Of course." And that's where we are. In my documents, it also shows, her renting a storage center, her writing out, can't wait to move out, moving out on the 1st. March 6th, trying to be out of here. Wife is trying to get out of that house because it's her idea to move into the Cloverdale home, and it recently morphed into living with her parents.
Is there anybody in the Cloverdale home now?
Yeah, so the plan was for her to serve them with a 90-day move-out notice to the tenants in that house so that she can move into it. That never came to fruition. Instead of that happening, we got served with this temporary motion. So it's kind of disingenuous to say my clients had notice of this motion to find a place to live. Well, we know where he can live. We know where she can live. We know where the parties can live. They have these rental properties. And if mother had followed the plan that she thought of, we wouldn't be in this situation right now. This is a waste of our time, a waste of course time to figure out who should live in the Pear Road house, when it's actually more beneficial for the mother to move back into the Cloverdale house, because that's the house the children have known almost the entirety of their lives. I'm not going to delve too far into parenting time. There's no dispute. My client was an involved parent. There was mention of requests of a psychological evaluation and findings of abuse, abuse, of conflict. I don't think that's appropriate here. The text messages literally just show two people who are breaking up who should no longer be together. These issues are going to go away once they're out of the house. Mr. Zandy talked about issues with my client coming home from several months ago that no longer exist, and the circumstances for that do not exist. I'm concerned about mother's rehashing history here about my client being authoritative. No, these parties have been mediating for months and months and months with a shared mediator, trying to come to some sort of resolution. This is not one party trying to push on the other. This is my client is a therapist by training and profession. He's just trying to work through this, albeit at a slow pace, this divorce. And if that comes across as authoritative, it may be because you do have to make a decision in a divorce. You do have to make a decision. We are here. We would rather have the parties make a decision than the court make a decision. So there's no reason for any evaluations. Mother in previous text message has agreed to the current parenting plan. My client would simply like a Wednesday overnight and a Thursday night overnight every week, and then alternating long weekends, Wednesday to Sunday. There's decision making should be joint. There's no 191 factors. Frankly, mother should not be trusted with sole decision making. There's been issues with the doctor, Lucas, banging his head. Mother wants to engage with this behavior, while the pediatrician has said, no, the best thing to do is to ignore it. The child stops. If you give it attention, the child will continue. And there's also some budding issues with preschool for Lucas, the 3-year-old. My client would like the child to start getting school ready. Mother seems to be resistant to that. We need joint decision making so we can work through these issues between the parties. The income of the parties, my client's wages for 32 hours a week, which is what he has historically worked is $4,052 per month, $3,000 net. The rental income is actually only $3,500 per month, which we would have to refactor should one of the parties move into the Cloverdale house, as they would lose about $2,500 in rental and mortgage, so about a net of $500 change if someone is going to move into that Cloverdale home. Wife, right now they've got her at minimum wage. I believe she works for $40 an hour as a massage therapist. There's no reason she can't work full days on weekends. 24 hours times $40 an hour is $4,100 per month. We ask that she be imputed to that wage. I think we don't agree to the sale of the vacant. It's actually a vacant lot. What Mr. Zandy is talking about. We have no objection to trying to get that thing sold. My understanding is the parties have had that on the market for several periods of time with no bites, but we don't disagree with trying to get that thing sold. I hope we can. I think that sums up my argument. Thank you, Ron.
Great. Thank you. Mr. Zandy, anything else?
Just real briefly, I mean, to suggest that it's just parties that are trying to make decisions, when you look at the communication, this is a guy who asked by my client for an $89 air filter for a car. And he says, well, I don't know what to do. I guess I'm going to get that. And he says, the fuck you are. That's an $8 part. Google it, Valentine's Day money if you want it. That's problematic. Calling your spouse the C word in front of a 3-year-old, that's problematic. These are not making decisions together and trying to determine what course you're going to go, dividing finances and kids. That's somebody who's a bully and who's trying to, again, step on toes to get what he wants. And it's pretty evident that's what happens. Reason they couldn't resolve things in mediation. Result is they couldn't resolve things in mediation. That's why we're here. That's why we need to get this in progress, because unfortunately the fear looks on paper and from these types of communications that the only thing that Mr. Furlong is going to agree to is what he wants. And therein lies the hang-up. My client did, and I think it's undisputed, as she states that, did look into living with her parents, did look into getting into one of these rentals because he's giving her no other choice than to do that. She was desperate and continues to be desperate to be out of this guy's purview and out of this guy's control. And unfortunately, then we have the issues of hijacking keys, blocking cars, taking cell phones and the like, which puts us in this position for the need to come and get some court involvement. That's where we are. The request is reasonable that my client has made. It also promotes the best interest of the kids and makes perfect sense from that standpoint. And this is absolutely a case where 191 finding of abusive use of conflict could be found, and we're asking if that's reserved, it's reserved, but this is pretty evident from the communications. And again, that's a small sampling of what we provided you. This is far and beyond two people who are trying to make decisions. He's telling her to F off over an $89 air cabin filter. That is not somebody who does that. That's somebody who's trying to walk all over her parents and herself and everybody who gets in his way to get what he wants. And I find it hard to believe that this is how he's advising people or counseling people in his practice, but it is what it is at this point.
In response to where your client is, they're indicating she's been out of the home for a month now. Is that accurate? Where is she residing? Is she with parents?
I don't believe that is accurate. I believe what's happening is she's gone to her parents' house. She's looked into the Cloverdale stuff. She's basically a peace home. She tries to go away. I think she has spent weekends at her parents'. I think she has tried to get out of the home knowing when he's going to be there. Otherwise, at last glance, my understanding was they're sleeping in separate rooms as kind of an awkward roommate situation, and she leaves when she can or when he makes her.
But my client's on the line, I think. Mr. Furlong, are you there?
Yes. Yep. I'm here, Your Honor. And yes, I'm here, Phil, Mr. Jones. And there is a text message from the time.
Who's living in the house right now, Joe? That's the only question we're asking you.
Yeah, I've been living here solely by myself since March 10th, the date that we had mediation. She sent me a text message.
Judge, are we having testimony? Is he represented by a lawyer or not?
Yeah,
I'm not. Mr. Zandy's over here casting aspersions. If Mr. Zandy can say, I think this is what's happening, I can have my client right here answer a question.
Well, I guess your information is coming from him. I doubt it'd be any different than what you said. So
I just wanted to.
I appreciate it.
Real evidence versus a lawyer's testimony.
The first and foremost, a GA, I am going to appoint a GAL. If Miss Wade, if I could have the next three names.
The next three names are Ann Height, Twyla Corey, and Keith Lawrence.
Mr. Zandy?
I guess I would strike Miss Corey.
All right. Mr. Jones?
I'll strike Keith Lawrence.
All right. So appoint Ann Height in this matter. We'll list the North 14th, is that home or lot, whatever, that can be listed for sale. Any proceeds of that, let's have placed in a trust account, assuming that gets sold in a timely fashion if it can, a trust account, and then we'll determine if any of that is going to be split up in the interim. They have a lot of rental homes. It doesn't, so I think one of them needs to live in the main home and one of them needs to move into one of the rental homes. In my initial review of the record or everything provided, I did make a note that Cloverdale was a kind of a primary home for a period of time, was mom's home prior to. So I guess having conflicting information about where mom and children are primarily residing, I'm going to order that a notice is given to Cloverdale that once that home is vacant, mom moves in there. In the interim, and this is kind of, my hope would be that Mr. Jones and Mr. Zanny could work through this a little bit, but in the interim, if mom has already moved out and is with parents and can be with parents for the next 90 days, then that's fine. I don't want 2 moves within 2 or 3 moves within a 3-month period. If she is actually still in the home Then Mr. Furlong needs to find another residence until that Cloverdale home is available to Mrs. As to, and I think the last issue we need to address is the request for attorney's fees. And then there was probably about a $300 difference in the income between the two parties. So attorney's fees and then the child support. I would agree. From what I've reviewed, it seems that the primary home, the Pear Road home, is probably the largest asset the family has. So the mortgage of that should definitely be taken care of. And I think that the not knowing what the mortgage on the Cloverdale home is at this point, I'm not going to. That puts a little bit of a hitch into things, but we thankfully have a little bit of time. So I am going to award attorney's fees to Mrs. in the amount of $2,000. And I set a 90-day payment on that before interest. The child support, I only got one child support worksheet proposed. It outlines 60. Is that what I'm seeing?
Yes.
So the request for is for $1,260.59. I'm going to set child support at this point at $1,000 a month. I'm going to work off the parenting plan because it's just a little cleaner that was proposed by Mr. Zandy. I'm going to reserve the 191 factors. I'm going to make major decision-making joint at this point. And I would say otherwise adopt it. There was a request, Mr. Jones, and I just want to make sure that I heard it right. He's asking for the alternate week to be Wednesday to Thursday instead of Thursday to Friday.
Wednesday to Friday.
Oh, Wednesday to Friday.
And then Wednesday to Sunday on the other week.
Okay. Instead of Thursday to Sunday and Thursday to Friday.
Yeah.
Okay.
He works on Thursdays, I believe.
Yeah, I thought there was just a request for the off week overnight to be just a different night, but he's asking for additional nights. I think there's a pretty significant amount of visitation. So I'm going to adopt the visitation proposed Mr. Zandy's order with the 191 reserve and decision-making being joint.
When you adopt, you're not adopting the psychological evaluation or that stuff.
Was that in here listed?
He wanted an evaluation or treatment for my client. I think that's not appropriate at this point. If the JL wants to, the GAL can. I don't think there's enough information for the court.
I see that here under number 4. I'll reserve on that at this point.
That's fine.
Sorry, I lumped that into the 191 portion, and it is.
No worries. I just want to be clear.
I guess if there's the one cloudy part about what I've ruled here is just the home situation. So obviously, hopefully the parties can clarify that and get these orders entered. If not, I'm happy to get more information and make additional rulings.
Right.
But hopefully it resolves itself by presentation, which we'll see. That would be great.
Presentation. So as far as a regular, next week is probably too quick given all that needs to be done. I have Fridays at 8:45. Otherwise, my next Tuesday isn't until May 9.
Oh.
I'm fine with that May 9th. I would try to get it out this week, but I don't have a legal assistant. Let's shoot for May 9th and then hope that we can just agree to the form of those and enter them on ex parte.
May 9th at 1 o'clock. Is that your?
Yes. Does that work for you, Mr. Jones?
It does.
All right. And then obviously if there's any of those orders that are agreed and you want to submit ex parte, I will sign and file them as soon as I receive them.
Great. Thank you.
All right. Very
All
well.
right.
Thank you.
Good luck, everybody.